asking the private sector organization of Jamaica to highlight their issues. You have not more than 15 minutes, members, so that we can start. So if the private sector is ready, could you just please turn on your video and your audio and indicate who is with you and start your presentation.
Thank you very much, Minister. Good morning to everyone. Can you all see me?
Yes, we see you very well.
Hi, good morning again. I'm Jackie Sharp, Vice President of the Private Sector Organization of Jamaica. And with me, I have Chuck Cameron, who is an attorney at law and also a PSOJ member. So thank you, Minister, for giving us this opportunity to provide our feedback on the NIDS Act. As you know, at PSOJ, we are fully supportive of NIDS because we see the long-term positive impact it can have on our people and our economy in the long run. So we are very happy to be participating. We formed a committee, a subcommittee within the PSOJ to review the act, and coming from that deliberations, we submitted some recommendations. And so I'm now going to hand over to Chuck Cameron, who is our key legal person on our subcommittee, to just run through the highlights of the sort of recommendations that we had made and try to stick within the 15-minute time frame.
Thank you very much, Jackie.
Over to you, Chuck.
Thank you very much, and good morning, members and Vice President. So I'm not going to read out the relevant sections. I'm just going to identify the issues that we have identified while referring you to the relevant section. So if I may first draw your attention to section 5, subsection 4F. In general, we have found that leaving the head of the entity to have the power to do anything, it is a bit wide, and in circumstances where the actions of NERA has the ability to, does restrict the right to privacy, we do want the powers to be very specific and not leave the head of the organization with the power to do anything in support of the stated objectives. We prefer if that wording be more specific or just deleted altogether, in light of the fact that his actions, by the nature of his responsibility, does significantly restrict the right of privacy of Jamaican citizens. If we were to move on to section 6.1b, in terms of consistency, we would suggest that we want to keep the language consistent with the Data Protection Act. And instead of using the word identity information, we are recommending that we use the word personal data. And the reason for that is that under the Data Protection Act, certain rights accrue to data subjects or citizens as it relates to personal data. So if it is intention, so we do want to have those rights accruing to all personal data that is being collected under the under this legislation as well. Moving to section 6.1e. This is one of our major issues. We do not see the inclusion of any parliamentary oversight, and we're of the view that this is inconsistent with good governance practices and administration. So what we have seen is that arrangements, the minister has the discretion to put arrangements in place, and it is a minister with responsibility that the buck usually stops with. Given the extensive reach of this legislation, and again, the extent to which it does restrict the right to privacy, we're of the view that Parliament ought to have some oversight role as opposed to the minister alone. This is further reflected in section 7, and our position simply is that too much power resides with the minister. The reporting framework is not clear on whether the authority reports to the minister or Parliament. So we are of the view that there can be much more clarity as to what the reporting lines are, and ultimately it should be overseen by a parliamentary committee?
Chuck Cameron, I can just briefly indicate to you that these issues, especially this one about the reporting, is a matter that has been brought up by many presenters. And I think there's a general feel that the oversight committee will be reporting directly to Parliament. So, you know, the inspectorate, we are going to revamp the inspectorate so it becomes an oversight committee reporting directly to Parliament. Okay.
Appreciated, appreciated, Minister. And we do note the several layers of lines of reporting. So we do appreciate that, and so we're even further pleased to hear that intervention, sir.
Yeah.
When we look at section 9.7, section 9, subsection 7, that is, well, given this age of technology and digitization, if we could just expand or specify what legislators meant when they said it in writing, and hopefully it would include electronic and other types of correspondence. I'm going to jump very quickly to section 14 that deals with the duty to inform of processing after cancellation. What I missed one. Section 11.1a, this is just a general comment as it relates to gender inclusivity. We are recommending that it read gender of individual. If we were to jump now to section 14 of the legislation, this deals with, well, this is a technical issue, and based on the information that we have and that was presented in the legislation, this is the position we formed. We're of the view that this section focuses on the cancellation of a national ID card. We know that this is a physical object, but it doesn't necessarily speak to the digital implications therein. Specifically, the PSOJ would want to know what happens to the digital information that is shown on the physical card and the digital information that it represents. So whereas we note that the card would be cancelled, under the Data Protection Act, data subjects have a right to know what data is being processed. So the legislation needs to actually set out what is going to happen to the underlying information and not just what happens to the physical card once a card is cancelled. Is it that once a card is cancelled, all the information remains on a database, or is it that it is stricken or removed from the database?
No, once it's cancelled, first of all, the card has to be returned to the NERA, but the information on the database is removed. Okay? In other words, if the PSOJ or any member of the PSOJ wanted to authenticate something for that individual, they will be told that it no longer exists on the database. Okay? So that would be effective.
In terms of the process, would it be left up to the citizen to attempt to query something, or will the citizen be advised upon completion of the deletion process? Because the authority does have that duty to advise.
Now, once it's cancelled, the person will be told that the data has been removed from the database. Okay, so, you know, if they would be advised that it will be removed from the database. What is not cancelled, however, is that the national identification number will remain with that individual for life, forever, even death. Okay, so that if that individual seeks to re-enter, then that number will be revived because the card would have been surrendered and kept. You get me? So the card will be surrendered by the individual and will be kept. So in the event the person re-registered, the same number will be assigned to that person.
Okay.
But the information in the database will be removed.
One issue that may not necessarily be appropriate for the legislation, but possibly some regulation or some guidelines, is how would a data subject then satisfy himself that that information has been removed, because that is a technical process, and when treating with personal data, there must be some level of transparency. So the committee may want to identify that process that can be independently verified or audited to say, yes, we have removed it, and here's a proof of removal, because in that digital space, we know we can just press delete on a computer, but it remains there. So thinking through some documented process that can be independently verified, I think is if it has not already been considered, we are of the view that that process should be in place, that it could be independently audited and verified.
Well, I'll ask the NIDS team to respond to that.
Obliged, Minister. If we were to move on to section 23F of the legislation, that primarily speaks to, well, we see where you have recommended that all the data be encrypted, in keeping with the Data Protection Act, and in particular, 7th Data Processing Standard. That legislation speaks to encryption and pseudonymization. And the thinking behind that, well, it is our position that this legislation ought to also promote the pseudonymization of the data. And the thinking behind that is, while encryption really protects data if it's leaked outside of the organization, we really also need to be very conscious and aware of the internal threat actors, because very often it is usually members within an organization, either by mistake or intentionally, that cause data leaks. And so where we adopt pseudonymization of the personal data, it offers an extra level of not only external protection, but internal protection. So it is, while the operators of the system need to be able to access certain information, everybody does not need to be able to see, doesn't necessarily have to see everything. So we are strongly recommending that in addition to all the personal data being encrypted, it is also pseudonymized.
Okay.
It is contemplated in this legislation that the information would be shared among third parties.
No. There's no question of sharing of the information in the NERA with anyone. What the NERA will be able to do is to authenticate requests from the PSOJ, banks, institutions, or any other government agency. But it's not a question that the data, let us say the data will be passed on, any individual data will be passed on to anyone. The only provision is in section 24, where the Commissioner of Police must go to a judge if they want any specific information. That's the only provision, section 24. Okay.
Thank you very much, sir. And it is, well, I should have been more specific. It is in relation to that accessing of information that we are concerned with.
All right, let me just clarify section 24, because in section 24(3), section 24, it speaks about any other law, coming to you in a second, or, as may otherwise be provided by this act or any other law. I think we have had a discussion on this, Chuck Cameron, and we want to say there that if information is to be provided by any other law, okay, that information will only be provided in a similar manner as the Commissioner of Police gets his information, that is by going to a judge. So to give you an example, let us say there's another institution, MOCA, that provides that, it could access information. Then MOCA head or FIB head, or any other law that provides for the information to be revealed, they would have to do a similar procedure like the commissioner, appeal to a judge ask the judge that this information is important for in the national security, etc., or for the prevention of crime. And in those circumstances, that is the only basis on which specific bits of information could be released in accordance similarly with section 24.3. Okay.
We are.
Thank
Thank you very much, sir. We are very comfortable with the legal basis in which information will be shared. What we are particularly concerned with is, having obtained that lawful order, what is the mechanism or the organizational measure that is put in place to ensure that data is shared in a safe manner, and once it comes in the possession of that third party, that the appropriate technical organizational measures are put in place. And to that extent, we are of the view and recommending that, consistent with the Data Protection Act, certain data sharing agreements be put in place where obligations to maintain the data in a certain manner, and the whole question of the length, a period of time that this data will be kept and how the data will be processed will be captured in this data sharing agreement. So one, having established a lawful basis, NERA needs to satisfy itself that how the data will be treated after it leaves its possession would be maintained and processed in accordance with best data processing standards.
Well, the position is that section 24 also indicates how the data will be treated and how it will also be destroyed. And section 30 emphasizes that the confidentiality, and if it is not protected, then persons could be fined significant sums of money. If the data is in any way released at all. Okay, the section 30 is a protective mechanism to ensure secrecy and confidentiality of the data that is shared, say, with the Commissioner of Police or under any other law, as we say, we will ensure. Okay.
So, obliged, sir. One of the beauties of the Data Protection Act is that outside of, well, it has really broken down into biteable sizes. How do you enforce confidentiality? How do you secure data? So we have always had the financial regulations that said that data should be treated confidentially. We have always had regulations that govern attorneys that says data should be treated confidentiality. What the Data Protection actually does, it actually sets out certain data processing standards that ought to be maintained. So it is those data processing standards and security measures we are of the view that should properly form part of a data sharing agreement. We don't.
Let me say, Chuck, that this NERA will be subject to the Data Protection Act. Okay, in fact, you will recall that the Chief Justice in Robinson's case emphasized the need for the Data Protection Act to be in place before any similar act as the 2017 Act. And so all the contributors, or many of the contributors, have indicated the need for the Data Protection Act to be in place before the NERA is actually executed. So we're aware that the Data Protection Act will protect, and the NERA will follow all the confidentiality and protective mechanism of the Data Protection Act. Okay?
Obliged, sir. I will move on to another section in section 24. And the issue we have here is that it is unclear in what manner and form the identity. Okay, so I think we have belabored this question of data sharing sufficiently. I will move on to section 24, subsection 7, subsection B, that speaks to the verification of the removal of data. And I'd raise this issue in relation to one of the sections I made reference to previously. So I'll not go over this again. So this is I'm now referring the committee's attention to section 30, subsection 2, and this is a section that deals with criminal liability for employees.
Right.
And we know that there has been a lot of discussion, and you have got a lot of feedback from the public on this issue. We have a very strong view on this question, Minister, and it is our view that employees of NERO should be faced with the same, if not greater liability than members in the public sector. Under the Data Protection Act, any data controller company, any employee of any company can be faced with criminal sanction.
Well, I can tell you that previous contributors urged us to look at the penalties for the members of staff. In fact, some persons have even indicated it should be a mandatory prison term. So the Joint Select Committee will be looking at the penalties if data is unlawfully shared. Okay.
And well, we are just suggesting there should be equity. So where members of the private sector are faced with criminal sanction, even when it's not unlawfully shared, if there's an error or a mistake and negligence that caused to some data processing breach, we don't think a government entity whose core business is processing personal data should have any less liability than members of the public whose core business is not necessarily that of processing personal data. So we would also invite you to take on board that principle when making that determination.
That is a remedy that has been suggested, like you, by other contributors. Okay.
Yes, sir.
That's been looked at.
And finally, as it relates to schedules 1 through to 3, we note that there's no limit on the number of terms that board members may be reappointed. There is on the table, but has not yet been promulgated, the Public Bodies Management and Accountability Regulations that has recommended that board members be reappointed for a specified term. While we note that this has not yet been promulgated, we are of the view that the board members in this instance, again, just to ensure and promote good governance, board members be given a fixed term, whatever that may be, but an agreed fixed term, and not be able to run without more and in an unended manner. Those represent the primary concerns of the PSOJ. As Mrs. Sharp has indicated, we are strongly in support of the legislation, as we do see and know the need and the impact it will have on our economy and society. Madam Sharp.
Chuck, that the NIDS team, we want to thank you and the PSOJ for those points that you have raised. The NIDS team, in fact, have prepared a detailed response to all these points. And then if there are any additional points that was raised by you, Kamika, could you just respond briefly to some of the points raised? And then we will also get this detailed response to you, Chuck, and the PSOJ, so that you can see that your submission was thoroughly considered and a response was provided to them. Okay, but orally, I think Kamika Pace will highlight some of them. Go ahead, Kamika.
Good morning, Minister. Mrs. Miller-Williams will actually be taking both PSOJ and the Love March movement today.
Okay. Janelle, would you go ahead then and give the response?
Thank you for that, Chairman. Okay, so in responding to PSOJ's submission, I will start off with clause 5, the National Identification and Registration Authority. They had identified an issue to state that the authority's power is too wide and unrestricted, which unnecessarily threatens the right to privacy of the citizen. And that the word anything is too broad, and that the legislation specifically sets out the power that it wishes the authority to have or to be deleted. So this issue was highlighted in previous submissions, such as the Norman Manley Law School. And we had responded that this clause is intended to facilitate the efficient operations of the authority in the performance of its functions. And as such, the authority will have to utilize these powers within the parameters of this legislation, the Constitution, and the laws of Jamaica. With respect to Clause 6, Board of Management, the submission had indicated that the language is inconsistent with the Data Protection Act, which speaks to personal data. And it was suggested that the definition of identity information as set out in the authority be aligned with the definition of personal data in the Data Protection Act. And at this time, I will refer to the Chief Parliamentary Counsel.
CPC, Judith Grant, are you on?
Yes, Chair, good morning. So identity information refers to information that might be required by the authority for the purposes of enrolling an individual in the National Identification Database. And it's the information that's listed in Clause 11. The concept of personal data, though, under the Data Protection Act is much wider. It's any information about a data subject that from which the data subject can be identified, whether by that information alone or that information together with any other information that is in the possession of the data controller. So that is much wider, and so it would not be appropriate in this context to import that definition, because that would be doing is empowering the authority to collect any sort of that type of information. But if you look at the items that are listed in Clause 11, you can readily conclude that all of those things are things that would constitute personal data within the meaning of the Data Protection Act. So by virtue of that, the authority would be a data controller for the purposes of the Data Protection Act.
Thank you.
If I may I comment, or shall I wait till all of them have?
Just let Janelle finish and then you can respond. Go ahead, Janelle. Are you finished?
Yes, yes. Okay. So in relation to the comments at Clause 6 and 7, the Board of Management and Ministerial Directions, the chairman had already indicated that the committee wishes to, or has the intention to review the governance structure and the oversight framework. In relation to Clause 9, National Database Seals, the Clause 9.7 states that the authority shall in writing notify the individual, and the submission had indicated that the term in writing is too vague in outlining the various formats for communication, and they had recommended that in Section 2 of the Act, a definition of in writing, which could include any form of electronic, digital, or print correspondence. And our response is that Section 7 of the Electronic Transactions Act indicates different forms of writing which are recognized under Jamaican law. With respect to Clause 11, identity information, they identify the issue of gender inclusivity, and they had suggested that we can restate to read gender of individual. But our response is that the bill is drafted in keeping with the recognized sexes stated in the Constitution, being male or female. With respect to Clause 14, cancellation of enrollment, the suggestion was that in accordance with the first data processing standard, the authority as a data controller has a duty to inform persons whether digital identity information is still being processed after cancellation. And clauses 14.3a and 14.6 state that upon cancellation of enrollment, the card must be surrendered and the national identification number shall no longer be utilized by the previously enrolled individual. Further details will be encapsulated in regulations as appropriate. Furthermore, identity information collected will be retained in accordance with the provisions of the Data Protection Act and in accordance with the applicable retention schedule. With respect to Clause 23, security of information, it was stated that encryption may not be adequate to ensure the confidentiality, particularly when information is being shared with a third party, right? And so it was suggested that information should be encrypted and pseudonymized. A similar issue was previously raised by 876 Solutions as it relates to anonymization. The committee may wish to consider this recommendation to provide for all 3 levels of securing data: encryption, anonymization, and pseudonymization. The authority, though required to utilize these security mechanisms, must be left with the discretion to apply the levels best suited to the specific circumstance. In respect of clause 24, disclosure of identity information, where it was suggested that there should be more detail in outlining the process for this destruction of information. This issue has been highlighted in several submissions, and the committee has indicated its intention to address same. And also in relation to another issue, that data sharing agreements should be mandatory between the authority and other data controllers. Our response is that reference is made to clause 31C, which places a duty of secrecy and confidentiality on every person to whom information is communicated under the Act, to treat the information with secrecy and confidentiality. It also requires such person to not disclose the information unless in accordance with the Act or the administration of the Act, and failure to comply with this requirement constitutes an offense in the bill. Data controllers are required to operate pursuant to the Data Protection Act and the wider data protection regime. As it relates to data sharing arrangements, reference is also made to clause 54F, which purports to allow the authority to enter into arrangements, which may include those which were referred, and also clause 8, which requires the public sector entities to cooperate in order to effectively administer the Act. In relation to clause 30, secrecy and confidentiality, in relation to your suggestion, the committee also indicated its intention to revisit the offenses and penalties in the bill. And with respect to your suggestions at schedules 1 to 3, the committee has indicated its intention to revisit the governance and oversight framework.
All right. Thanks, Janelle. Chuck Cameron, you have a short response. And by the way, the administrator, a number of members of the Joint Select Committee are trying to get on. I know Donna Scott Monty said she was unable to get on. Is she on now? Donna, are you on? Okay, administrator, could you please let her? Okay, continue on, Chuck.
Yes, sir.
No, Minister, I'm in. I changed my device and I got you.
All right, wonderful, Donna, thanks. Okay, Chuck.
Yes, sir. Just one issue as it relates to the definition of identity information. If it is, there could be some language to suggest that the same, well, what the thinking behind that recommendation was that rights, the Data Protection Act is only invoked or only relevant to personal data and not necessarily anything outside of personal data. So if there can be some clear language that the same rights that accrue to personal data for data subjects is the same rights that accrue to identity information, that's a concern, that you can only invoke the Data Protection Act in relation to personal data.
I suspect though, Chuck, and Judith, you can assist me, or member of the NIDS team. I suspect that every item, not only in every item, will be under the protection of the Data Protection Act. Isn't this the case, CPC?
Well, Chair, I had mentioned that looking at the list there, you would have to apply the definition in the Data Protection Act to see whether they fall there. And in my view, everything that's listed there would.
Right.
But again, that is really the function of the Data Protection Act. The definition there would have to be applied for you, for any information for you to be able to determine whether that act applies.
Fine. All right. Is that okay, Chuck?
Yes, sir.
All right. I want to thank you for, spending so much time to examine the bill, and thank you and the committee and the PSOJ for participating. Please keep in touch as we proceed to report to Parliament, to debate it in Parliament, and hopefully to execute the bill itself later on this year.
Has been
Thanks.
noted.
Do we have the Love March movement available now?